It helps that when you hire counsel, we actually know what we are doing. For example, a lot of attorneys try to make a marital settlement agreement where the other parent or husband or wife is beholden for paying for college or graduate school or some such other similar educational mechanism for their kids. This is a noble intention and a noble idea. And I sometimes recommend that if you're paying somebody child support, maybe you can make an agreement that if both parties are well off, both parties are employed, maybe then that money, instead of going to one parent or the other, the payor or the payee, maybe that money can instead be better spent putting it in a child's prepaid college fund, something that can help them in their future. So it's still, in essence, a form of child support, but it's used and applied for another thing to make child support more palatable to the parents. Nobody loves paying child support. It's not exactly a joy and a pleasure to have to pay. And clearly people have a sort of resentment about it, and there's a continuous never-ending stigma associated with paying child support. But back on topic. Sometimes people will put in a marital settlement agreement that a husband must pay for their minor children's college wherever they go up until $150,000 to avoid them from going into student debt. A noble intention. Really lovely. I admire that. I appreciate that. And yes, a marital settlement agreement truly is a contract. But you know what it isn't? It isn't enforceable. There is case law out there that says if you try to enforce a marital settlement agreement for the payment of a child's college now that that kid is an adult, well, technically that child was not a party to the contract. It simply mentioned them. And unless that child is suing the parent that made that promise in that contract, there's very little that a former spouse can do to enforce it. Because Florida public policy and family law does not obligate either parent to pay for a child's college. It simply does not. College is not in Florida statutory law, in family law, as a requirement. You do not have to pay for their private school either if they are in high school. Nothing that requires payment of education, generally speaking, is a requirement in family law. It simply is not. Therefore, even if it is in your marital settlement agreement, the likelihood that you could file a motion for enforcement and have that motion for enforcement before a court and have it succeed would mean that the court likely has no knowledge of case law and you haven't informed them, or your opponent hasn't informed them, or nobody's read Florida statutory law, or they just simply think it might be a moral outcome. You made a promise. It's in writing, and therefore you should fulfill that promise. Well, I would argue that if that kid is now over 18, then that kid is the one withstanding and not the former spouse. Because the former spouse wouldn't be benefiting from it. That child who's no longer a minor and is now of the age of majority would be benefiting from it. So perhaps if that party wishes to intervene in some way, shape, or form, or maybe even transfer somehow that domestic relations case into a civil action, there might be something there. But short of it, there is case law that very specifically says, including in the 5th District where I mostly practice, there is case law that very specifically says that that is a no-go. That you're not going to be able to have that paid for. So, with that in mind, I want to share with you, if you'll permit me, just a little bit of case law that specifically addresses what happens in this particular circumstance. College tuition. This is from the case of Southard versus Southard. Maybe it's pronounced Southard versus Southard. Groveland, Disneyland, Disneyland. Pick your poison, tomato, tomato. Quote, a contractual duty to pay a child's college tuition and expenses cannot be enforced by contempt. Florida 5th DCA from 2000. As far as I know, this has not been overturned. Of course, you should always check if you're going to court. And that's what we call shepherdizing, or doing some sort of a search history to find out if a decision has been questioned, overruled by a higher court, questioned by a sister or brother jurisdiction, or district court of appeals, or what have you. Overall, I do not believe that if you have a provision in there for the payment of post-secondary education, I do not believe that the court has the jurisdiction, i.e. power, to enforce that provision absent that child who's now an adult suing and intervening in some way, shape, or form through a creative lawsuit that I haven't heard of before to enforce the payment of that. And we've heard of these kinds of cases in the national news, though I have never heard of one in this context.